global happenings today. We communicate, we analyze global news. Stay tuned.
Hello, beautiful people. Welcome to Global Happiness Today. The story of Nnamdi Kanu and how he was being abducted. To some persons, it's a bit hazy. Right now, Nnamdi Kanu has come all out and he has explained the pains he went through. But they have decided not to just take the story for what it is, but they have decided to make it more bold. Like the lawyers of Nnamdi Kanu have decided to do the needful. AGF Malami is now in the know, and they are mandating all this to be done. From all indication, many heads are about to roll. Many heads may likely go down. But before going to the news proper, to give you the full details of what happened to Nnamdi Kanu, the people involved, and all what ought to be done, plus many other things within the news. Like and subscribe to our channel by clicking on the right subscribe button beside it. You'll see a bell notification icon. Please go ahead, click on it to get notified as soon as we update our channel on YouTube. This is a very sad one, I must say. Nnamdi Kanu's special counsel, Barrister Aloy Ejimakor, has asked the Attorney General of the Federation, AGF Malami, Senior Advocate of Nigeria, to initiate the prosecution of all persons that are directly or indirectly involved in the alleged brutalization of his client during and after his rearrest and transfer from Kenya. In a letter obtained on Monday evening directed to Malami, Ejimakor explained the need for the minister to ensure a sanction on those who initiated the controversial capture of Kanu in Kenya in June 2021. The letter, dated 20th of March 2022, elucidated how Kanu was arrested, allegedly manhandled and brought back to Nigeria without a legal process or pronouncement from either the Kenyan court or the Nigerian court. Ejimakor noted that his actions were based on instructions of Kanu, adding that the Constitution of Federal Republic of Nigeria 1999 is against the torture of any person placed under investigation or held in custody of any person in authority. Ejimakor's letter reads thus: "We are solicitors to Nnamdi Kanu on whose behalf and instruction we must respectfully bring this complaint pursuant to Section 1A and B, Section 5, Section 6 of the Anti-Torture Act 2017 and Section 174 of the Constitution of the Federal Republic of Nigeria. According to the information given to us by our client, the details of this complaint are as follows. 1. Our client entered Republic of Kenya on his British passport on May 12, 2021 and was admitted as such at Jomo Kenyatta International Airport, Nairobi. After his admission, he settled in at a temporary location in Nairobi, Kenya. On June 19, 2021, our client drove himself to Jomo Kenyatta International Airport, Nairobi, Kenya on a personal errand. As soon as he pulled to a stop at the parking lot and alighted from his vehicle, about 20 well-armed persons violently accosted and abducted him, handcuffed him, blindfolded him, bundled him into a vehicle and sped away. His abductors took him to a secret private location, not a police station, somewhere in Nairobi, Kenya, and chained him to the floor. He was neither shown a warrant of arrest or extradition, nor told why he was abducted. The abductors did not tell him who they are, but from their conversations, he surmised that they were working for the government of Nigeria, that's GON, and its security agencies. While chained to the floor, his abductors took turns beating and torturing him, to the point that he fainted several times and was intermittently revived when they poured cold water on him. During the tortures and beatings, his abductors taunted him verbally, degraded him, and called him a separatist Igbo Jew. They also told him he would be expelled to Nigeria to face death. He was chained to the floor for 8 days and was thus forced to relieve himself of urine and excrement where he was chained. Throughout the duration of his secret captivity and torture, he was not allowed to bath and was fed only on blood bread once a day and given non-sanitary water to drink. and except for the presence of his abductors, he was in solitary confinement the entire 8 days. Section 3, subsection 2 of the Anti-Torture Act states that secret detention, places, solitary confinement, incommunicado, or other similar forms of detention they where torture may be carried on are prohibited. The inhuman treatment, cruelty, and degradation to which the abductor subjected our client and the external and internal injuries he sustained therefrom, coupled with his pre-existing poor health, made him to live in dread, fear, and terror that he was going to die in captivity, and his body disappeared. His anguish entreaties to his abductors to get him some medication for his hypertension, heart condition, and physical injuries were inhumanly refused, and his pleas to be taken before a court or even official police or other law enforcement facility or allowed a phone call were flatly refused. Throughout the 8 days duration of the captivity and torture of our client, his torturers were in constant telephone conversation with and taking directives and instructions from the Nigerian High Commissioner to Kenya and other Nigerian officials. Section 2 of the Anti-Torture Act makes a person complicit in torture when it is inflicted by or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. Similarly, Section 8, subsection 2 provides that a superior military, police, or law enforcement officer or senior government official who issues an order to a lower ranking personnel to torture a victim for whatever purpose is equally liable as the principal. On the 8th day, his abductors brought him out of the house, put him in a car, drove him straight to the tarmac of Jomo Kenyatta International Airport, where they evaded Kenyan immigration and forcefully bundled him into a private jet that departed the airport before noon on June 27, 2021, and arrived at Abuja, Nigeria in the early evening of the same day. Throughout the duration of the flight from Nairobi to Abuja, our client's wrists and ankles were manacled so tightly that he was in extreme physical and mental pain for the entire duration of the flight. He also had the muzzle of a gun pointed to and roughly rubbing the nape of his neck. Throughout the duration of the flight, on arrival in Nigeria, our client was taken to and detained at the headquarters of the Nigerian Intelligence Agency (NIA) in Abuja. He spent the first night at NIA detention facility, sleeping on the floor with very bright electric bulbs deliberately left on throughout the night, thus causing him extreme bodily heat, sleep deprivation, and mental anguish. Our client states that from 29th June 2021 to date, he has been subjected to solitary confinement lasting for 23 hours each day at the headquarters of the State Security Services in Abuja. Since then, our client has repeatedly requested independent medical examination by a physician of his own choice, but the requests were denied. Section 7 of the Anti-Torture Act provides that a person arrested, detained, or under custodial investigation shall have the right to be informed of his right to demand a physical and psychological examination by an independent and competent doctor of his own choice after interrogation, which shall be conducted outside the influence of the police or security forces. The medical report shall include in detail the history and the findings of the physical and psychological examination and shall be attached to the custodial investigation report, otherwise such report is deemed void. Now, in reference to the public statement credited to the Kenyan government over the extradition of Kanu, Ejimakor said that the government of Kenya has exonerated itself. He stated, the government of Kenya, GOK, has publicly denied complicity and involvement in the said abduction, disappearance, torture, and extraordinary rendition of our client, and asserted in judicial proceedings that there was no extradition, expulsion, or deportation proceedings against our client anywhere in Kenya. In particular, GOK asserts that's government of Kenya said that its official record indicates that our client is still in Kenya. He further said our client has life-threatening serious health conditions, namely heart disease, and hypertension, which have been dangerously aggravated by the mental and physical torture he was subjected to. It is our considered position that the totality of what happened to our client, as mentioned above, inarguably met the definition of torture under Section 2 of the Anti-Torture Act 2017, which also states that Section 9, subsection 1, that a person who contravenes Section 2 of this Act commits an offence and is liable on conviction to imprisonment for a term not exceeding 25 years. Furthermore, Barrister Ejimakor pleaded with Malami to take prompt measures to initiate the prosecution of all persons that were directly or indirectly culpable in the torture of Kanu, irrespective of the severity of his offence levied against him. It is our further position that regardless of the severity of the offences levied against our client, there is absolutely no justification for the egregious torture our client endured. Section 3, subsection 1 of the Act provides that no exceptional circumstances whatsoever, whether a state of war or a threat of war, internal political instability, or any other public emergency, may be invoked as a justification for torture. In view of the foregoing, we hereby make the following prayers: that, consistent with the provisions of the Anti-Torture Act 2017, the Office of the Attorney General take prompt measures to initiate the prosecution of all persons that were directly or indirectly culpable in the torture of our clients. For your ease of reference, Section 5 of the Anti-Torture Act provides that subsection 1, a person who has suffered or alleges that he has been subjected to torture shall have the right to complain to and to have his case promptly and impartially examined by a competent authority. 2. That the competent authority under subsection 1 shall take steps to ensure that the complainant is protected against all ill treatment or intimidation as consequences of his complaint or any giving of evidence. That said, prosecutionary action be levied in line with Section 8 of the Anti-Torture Act, which provides that subsection 1, a person who actually participates in the infliction of the torture or who is present during the commission of the act is liable as the principal. 2. A superior military, police or law enforcement officer or senior government official who issues an order to a lower ranking personnel to torture a victim for whatever purpose is equally liable as the principal. 3. An order from the superior officer or from a superior in the office or a public authority shall be invoked or shall not be invoked as a justification for torture. 4. The immediate commanding officer of the unit concerned of the security or law enforcement agency shall or is held liable as an accessory to the crime for any act or commission or negligence on his part that may have led to the commission of torture by his subordinate. Conclusively, Barrister Ejimakor knew or drew the attention of Malami to the provisions of Section 1 of the Anti-Torture Act, which states that the government shall ensure that the rights of all persons, including suspects, detainees, prisoners, are respected at all times, and no person placed under investigation or held in custody of any person in authority shall be subjected to physical harm, force, violence, threat, or intimidation, or any act that impairs his free will, and fully adhere to the principles and standards of the absolute condemnation and prohibition of torture set by the Constitution of the Federal Republic of Nigeria and various international instruments to which Nigeria is a party. You've heard it all.